Very good evening, everyone. Welcome to LawPutra YouTube channel, guys. So today's topic is high seas on international law. So we are going to see what high sea mean and the laws related to high sea. So this is something which is related to the international law, and it is governed by the convention which is signed by 63 dignitaries, and it governs the sea laws, which includes India too. So let's get to know what it is. Hugo Grotius in 1609 mentioned that sea is something common to everyone and no state can have sovereignty over it and have rights on it. He has mentioned it in his legal maxim Mare Liberum, so which means free sea. So the state cannot have rights. There are certain limits for every country to have and exercise rights on the sea waters. So there are several things which need to be noticed in this one. So let's get to know what are they. In the year 1982, the law of sea was established under the United Nations Conventions, which is also known as UNCLOS, United Nations Convention on Law of Seas. So this governs the law, and it was established in the year 1982, and this states that how the law should be applied when governing the sea bodies. Just like municipal matters are being governed by the state, which is internal, this one is governed throughout internationally. Preservation of minerals and every other natural elements which can be obtained. So to preserve the ecosystem, preservation of high sea and maintenance of it is very much important. So when it comes to the natural resources, the state can exercise its right only up to some extent and not throughout. So there are several things which is related to the freedom of high seas. That is freedom of navigation, freedom of fishing, freedom of laying pipelines and submarines, freedom of flyover over the water bodies, and freedom of scientific research, and freedom of establishment of artificial islands. This is divided into four groups. They are economic zone, continuous zone, continental shelf, and territorial sea. The state can exercise its power depending on what zone it is. So let's start from territorial sea. Territorial sea is the land which is adjacent to the state water bodies, from which 12 nautical miles is calculated to be territorial sea. And during the 18th century, the cannon fire which is being shot, which will be used to calculate the length of the territorial sea. The shot of the cannon cannot be always relied upon, because it covers only a few distance. After the establishment of UN conventions, this method was dropped, and that's when they started to calculate it as 12 nautical miles. There is a concept called innocent passage, by which any ship or boat can pass through any other state's water bodies, and it can be done without the disturbance of the state's interest. So this again is divided into three rules which shouldn't be broken. One, the water body through which the ship is going should have a genuine interest and should not be something illegal. And second, it should not hamper the defense mechanism which is being laid upon. And the third is the exercise of weapons, collection of fishing activities, pollution, all these things. So these three things should be kept on mind before getting to apply this concept of innocent passage. Simply gives you the power to move around in the water bodies irrespective of which state it belongs to. So next one is contiguous zone. So this contiguous zone is calculated 12 nautical miles from the territorial sea. Herein the state cannot fully apply its law and take control over it. It comes under the control of customs, immigration law, and regulation of the territories. Next is contiguous zone. This is calculated by 200 nautical miles right from the continental shelf. So herein the state has only the rights and powers to explore and exploit the natural resources, and if any other state wishes to explore and exploit the natural resources belonging to the other state, it has to take permission, and this is usually calculated by the biscuit method, which is 300 nautical miles, isobath 2500 meters from the continental shelf. So this is somewhere crucial, and it is only meant for exploration and not for anything else. So this includes the submarine and the seabed too. So this is deep inside the water where submarines used to be going around. So this cannot be taken control or have access unless and otherwise it is very essential for the growth and development of the state's economy. Next is exclusive economic zone, which is a combination of continental shelf and contiguous zone. So this is calculated with from the baseline of territorial sea up to 200 nautical miles. So this is a combination, as I said. This is to be explored and not overexplored or exploited. The state can exercise its power only for mining and for the development of the economy, and this accounts only for the research purpose and nothing more. So these are the four types under which the high seas are divided. So this convention on high seas was signed in the year 29th April 1958 and was brought into the force by on September 30, 1962. So the third UNCLOS meeting which happened in the year between 1973 to 1982 brought new conceptions which is governing the high seas, and it has brought many new restrictions. The Convention of High Seas is nothing but simply a treaty signed by all the United Nations which is ready to accept this, and it is a codified law which governs the water bodies. So any cases which is being brought regarding this crossing of boundaries, borders, seabed, contingency zone, all these are brought only based upon the convention which is being signed by the nations. So Convention on High Seas was signed in Geneva, and it came into force, as I mentioned earlier, on 30th September 1962. The state parties to this convention desiring to codify the rules of international law relating to high seas, recognizing that the United Nations Conference on Law of Sea held at Geneva on 24th February to 27th April 1958. So herein there are many articles which has been framed here. So out of which the Article 3 is something which should be notable. The basic principle of these high seas is that no state shall the basic principle of high seas is that no state shall claim the right over it and say that this belongs to us and this is our area and you cannot enter. So that's not gonna happen. So if a state does not have a sea coast, it should be let to go through freely. So any case which is being brought out on basis of this dispute between two countries boundaries, when it comes to any problem of crossing of the lines, this will be taken into consideration only based upon these laws which is being mentioned in this Geneva Conventions. I mean under the High Sea Conventions which is signed in Geneva. This is all about high seas. Let's get to meet in another video. Please do like, share and subscribe LawPutra YouTube channel. Thank you guys.